Can you hear me, Rishi?
Yes, I can hear you, Mr. Naga, loud and clear.
Okay.
We will start at sharp 3 o'clock.
Sharp 3, yeah? Okay. I will start off by, so you will highlight the fact that Dato is delayed a bit.
No problem. Yeah. I will start off with you and we will take it as it goes.
Slide number is, I think, is 11.
Right. Okay, let's begin. Hello, everyone, and welcome to today's session. I am Rishi, and I'll be moderating today's webinar in relation to appellate advocacy strategy in presenting an appeal. We have two speakers lined up to give their insights today, but Datuk Naban is slightly to have Mr. Naga take the lead. And before he starts, I would just like to say a few words insofar as his background and profile is concerned. But before that, in relation to appellate advocacy, the purpose of this session today is to share insights insofar as the presentation of an appeal, given the paradigm shift that appellate business has gone through during the last 2 years at the very least, given the circumstances arising out of the pandemic, the shift into online hearings, time limits in relation to presenting an appeal, the effects upon oral advocacy, so on, so forth. So a bit about Mr. Naga. Mr. Naga joined the RDS family in July this year, prior to which he had an illustrious career in shipping litigation and maritime insurance. He is also actively involved in other practice areas such as aviation, building and construction disputes, as well as general civil litigation. Mr. Naga was also the former president of the Malaysian Maritime Law Association and a former member of the International Pacific Bar Association, where he had presented a number of papers over the years. Called to the English Bar in 1979 and the Malaysian Bar in 1980, Mr. Naga has been in practice for more than 40 years and has appeared in a number of landmark cases. He has acted for large multinational corporations and many blue chip companies in Malaysia, and is also regularly instructed by foreign companies to take up briefs in Malaysia and outside. He is a highly reputable figure in the Malaysian legal industry, with many describing him as a charismatic, mature, and experienced practitioner. As you can see, we also have Datuk Naban, who has joined us already. So I will give an introduction of Datuk Naban's profile now as well, before Mr. Naga starts his presentation. Datuk Naban is a senior partner of the firm with more than 40 years of experience in legal practice. He graduated from the University of London and was called to the English Bar in 1980 and the Malaysian Bar in 1981. His area of practice includes appellate counsel work, tax and customs litigation, corporate commercial litigation, and arbitration. Datuk Naban is a highly acclaimed Band 1 tax lawyer, as ranked by Chambers Asia, along with other platforms as well. Despite his years of practice, Datuk Naban still exudes a fresh and tireless enthusiasm for the law, which is evident from his various publications, co-authoring the Halsbury Laws of Malaysia, the Revenue Law chapter, and co-authoring the Malaysian-Singapore tax cases in digesting English. Datuk Naban is recognized by clients for his sound advice on resolving disputes, his appellate advocacy, along with his cross-examination skills. He is also said to be a mature, composed, and technically sound legal strategist. Now, to our dearest audience, if you have any questions, feel free to type it in the Q&A box, and the speakers will attend to as many questions as possible after their respective presentation. Now, without further ado, I would like to welcome the first speaker, our first speaker to deliver his talk. Mr. Naga, over to you.
Good afternoon to everyone. Can you all hear me? I hope you had a good lunch, and we are starting off with advocacy. What is important is, before I go on to my slides, talk to you a little bit about advocacy itself. As you know, that advocacy has transformed from physical advocacy now to Zoom hearings. But what is important here is this. Our talk this afternoon, it basically deals with advocacy per se, and it makes no difference whether it is either by Zoom, online, or by way of physical advocacy. So the area of advocacy is basically about trying to influence the appellate judges to persuade a decision maker's order as to whether it should be reversed or upheld. That is the basic skill of an advocate. The skills that are required for a good trial lawyer might not necessarily be the same as that would be called upon for purpose of an appellate lawyer. They might have different skill sets that is required. Now, as I remember, in fact, it was Datuk Naban is the one who told me many, many years ago that one senior advocate had advised him that no matter how senior you are as an advocate, you will always have a tinge of butterfly in your stomach before the commencement of any appeal. And if you have lost that feeling or a sensation, it might then be a good time to change one's profession. So that is important. Everyone would feel that. And that is important in the sense that you would have a sense of commitment. You would have sense of the fact that you want to do the best to persuade the appellate judges the basis why you either think the decision of the trial court is correct or it's wrong and it should be reversed. So that talks basically about, generally about advocacy. The main challenges of an appellate advocate, if you are an appellant who's appealing against the decision of the trial judge on a finding of fact, is to reverse the finding of fact by the trial court. That is not an easy objective to achieve in the light of the fact that the appellate judges do not have the benefit of hearing or listening to the witnesses. All they have is the evidence, the notes of evidence before them. So as an appellate advocate, it is very important that you master the evidence that was led before the trial. If you had conducted the trial from the very beginning, then it would have been much easier. But if you were to, if if you were commissioned to come into the appeal after someone has completed the trial, then you would have to go through the whole notes of evidence and to master the evidence that was led before the trial judge. Because your main objective here is to attempt to reverse the finding of fact. And usually the appellate courts are reluctant to reverse such finding unless it is a very clear error of inference or error of law. And it would be important for you to highlight that aspect of the points. Further, these are the important issues or challenges that you would have to face as an appellate lawyer. And in order to prepare for your appeal, this is what is important. You would always have to fully prepare. Now, if you're not prepared for the particular appeal, you will not be able to persuade the appellate judges. Now, what do you mean by getting yourself prepared for the appeal? Now, one is, of course, mastering the appeal record, and secondly, the points of law and the rules of evidence. And you have to, at all times, expect the unexpected might be raised at the appeal stage, either by your worthy opponent or by the judges. And at this point, I think it is important to highlight that it is essential that you don't ever underestimate your opponent's ability or his brief. If he is for the respondent, he would be defending the decision of the High Court judge or the trial judge. Or if he is for the appellant, you would have to then defend the trial judge. So these are the important roles that one would have to play as an appellate advocate. And some basic points that you would have to remember in the course of your submission before the appellate court. One is basically you got to be prepared to address all the issues. I remember the story of which I think it might be interesting for the audience, i.e. a senior silk in the course of his submission before the Court of Appeal started to submit on basic principles of offer and acceptance in the law of contract. And one of the irate judges interjected and questioned him as to why he has to go into basic tried principles. And this is what he retorted back. He said, "My lords, that was the mistake I made in the court below." So the moral of the story is, don't ever assume that the appellate judges would have addressed all the issues that might be relevant to your appeal. It is important that you are able to address whatever issues that is raised, either by the opposing counsel or by the judges. That is what you mean by getting yourself prepared for the appeal. Now, in the course of the submissions, it is important that you would have, by the time it reaches the appeal stage, you would have already filed all the necessary submissions, your written submissions, and your outline submissions as well. That is sometimes called the skeletal submissions. The first thing to remember about written submissions, sometimes it can be very bulky and not necessarily all the trial judges or all the appeal judges would have read your written submission. So don't go on the assumption they would have gone through the submissions. You have to go on the premise that they have not gone through the written submissions. So you would then have to rely on your skeletal outline to set out your case. Now, how do you attract or how do you grab the attention of the judges in the appellate court? One of the ways is to start off with your skeletal submission with some interesting legal principle or interesting set of facts, which would directly attract the attention of the appellate judges. And that is very important. If we were to start off the hearing with the opening line of that this is the appeal against the trial judge dated on such and such a day, I believe that the judges might close their mind. And as you would know, the attention span is short. You would have to persuade them to support your appeal in the way that would attract the judges. Now, one of the ways to do it is to highlight your good points. And you would have to prepare an order of merit and focus on the good points, because if you were to start off with the bad point, the chances are you might lose your good points. So this is an issue that you have to be fully aware of, and make your submission as succinct as possible and as interesting as possible. By the time you start your actual submission, you might have forgotten your skeletal submission. You have to proceed with the submissions that the skeletal submission that you have prepared out of your own memory. And one way of trying to keep the attention of the appellate judges is to add historical or social context to add to the submission, which would keep the attention of the appellate judges in respect of your submission. Another takeaway is make sure that you would answer all the questions posed by the appellate judges. There have been occasions where the appellate judges feel that you are trying to avoid the questions, you're trying to avoid answering the questions. Now, if you need to refer to the documents in the appeal record before you are able to answer the questions, get the permission of the court. You could possibly highlight the fact that you would like to attempt to answer the question by referring to this particular document in the appeal record. So they will know that you are drawing their attention to the document in the process of answering the question. And this is very important. Don't just shoot off by going through your documents before getting their permission to refer to the documents. If you don't, they might draw adverse inference to the fact that you are trying to avoid answering the question. Now, if you again, in the course of the submission, if you require to have a short consultation with your co-counsel or your junior counsel, again, get the permission of the court. Or just inform them that you have to have a short discussion with your co-counsel. That is important. Don't just close off the judges and have a short discussion with your co-counsel. The other important point I think that one would have to be ready for is to reply to the submission of your opponent counsel. Now, what happens is in many cases, we have seen appellate advocates just sit and listen to the opposing counsel's argument without taking down any short notes of what they would need to reply. And it is important that when you're called upon to reply, you then would have to address all the issues that has been raised. And that would mean you need to refer to the documents. You got to be familiar with the documents in the appeal record, and you would be able to, then you would be able to refer to it draw the attention of the judges. And that is important. Hardly there are cases where the appellate court would indicate to the appellant advocate that there would not be any necessity to call on him to hear the reply. But in most complicated matters, you would have to be ready to reply to your opponent counsel. And that is very, very important. Now, let's go on to the other point, is decorum. You got to maintain your decorum. You got to be firm to advance your argument in support of your appeal, and you have to always be polite. And that is very important in the sense that as a senior advocate, the appellate court would not get the impression that you are in any way trying to belittle your opponent counsel, assuming if he is a junior counsel. And it is important for you to follow the decorum and always be courteous to the court and to your opponent. And that is important. Now, let me take you to the slides now. I will leave most of the slides that are to be presented by Datuk Naban. I will take you all to the important case of Tidak Murdi, which is a 2020 federal court decision. A recent decision, and usually the federal court does not deal with issues of advocacy in their grounds of judgment. And in this particular case, I believe the court must have felt that it was a right time to express their views on the standard of advocacy in the appellate court. And Justice Nalini Padmanabhan in the federal court took pain in setting out in great detail how she expects appellate advocate to deal with the appeals. Now, she highlighted, if I may take you to slide 11. Now, she started off by dealing with the duty of an advocate and solicitor as officers of the court and their overriding duties to the court. And he went on further to highlight the fact that the advocate is there to persuade the tribunal that his client's case should prevail. Now, and surprisingly, she went further down on my slides, slide 12, where she went to the extent of highlighting how a decided case should be presented to her, how your proposition should be referred to in the course of your submission. And it's quite interesting, if I may just read paragraph 67 of the grounds of judgment in sub A, says how a passage cited is applicable to the matter before the court. Don't just cite passages from a decided decision without highlighting the fact that why you think what you're citing is relevant to the facts of the case that is before the appellate court. And if you're citing an authority, cite the nature of the case cited, and that goes on further to say the facts of the case. There have been a lot of occasions where counsels have referred to propositions in decided cases without referring to the facts of the case that they are citing. And this is an issue, this is a concern by the appellate court, because in lots of occasions you would come across situations where counsels would have cited a case which is out of context, the facts are completely different from the facts that the particular advocate is advancing before the appellate court. So it is important to set the context of the facts before the appellate court and then refer to the proposition of the law. And this is what she has highlighted in the judgment. In paragraph D, she highlighted that by saying the context in which statement relied upon was made and whether the statement amounts to ratio or is an obiter. That is equally important because there are decisions that you would have read where certain statements or points of law which are merely made by way of an obiter ratio rather than a ratio of the case. So it is important to highlight that the proposition that you are advancing is a ratio or an obiter. It's not that you can't cite a proposition that is merely an obiter, but you would have to highlight to the appellate judges. So they would be guided by you. Bear in mind that the appellate judges are sitting there to be guided by the appellate advocate. So it's your duty to lead them. Now, F, where the case is being cited for a principle of general application. That is again an issue that the federal court seemed to have taken. Obviously, there's been appellate counsels who have cited principles without identifying whether it's a general principle or not. And the last is whether the statement comprises an expansion of an existing principle, which has to be, which I think the appellate advocates would have to bear that in mind. And lastly, she highlighted the fact that there have been situations where randomly advocates have cited passages of little or no assistance to the court, and obviously would have wasted the court's time on that. So these are the few pointers and issues that I would like to highlight, and I believe the rest of it will be covered by Datuk Naban. And with that, I will rest. Well, people say we will rest our submissions, but I will say I will end my speech at the moment and then wait for the question and answers at the end of Datuk Naban's presentation. Thank you.
Thank you very much, Mr. Naga. So as you all have seen, that was a very structured presentation insofar as basics of appellate advocacy is concerned, but fundamental aspects of appellate practice, key pointers, namely presumptions in relation to the judges not having read the submissions, going in strong insofar as points are concerned. So it was a broad overview along those lines. The role you are playing as an advocate, as a guide, and when you are playing that role, making the assessment whether you are someone who is very well versed with the facts, someone who is involved in a trial stage, or you have come in at the stage of appeal and your onus and responsibility of having to go through records, appeal records, understanding the evidence, so on and so forth. And eventually later, there will be a bit of discussion insofar as the shift to online hearings and therefore having access to viva voce evidence or evidence at the High Court. Technically, they do these days, and how that impacts upon the whole audiovisual aspect of the law and the understanding thus far. So then we move on to Datuk Naban, who will be spending a bit more time insofar as assessment of the advocate when it comes to the judge, the attention of the judge being pivotal, being the currency of the advocate, the appellate advocate, and how to manage that aspect. Over to you, Datuk Naban.
Good afternoon, colleagues. Essentially, I think it is important when you appear as counsel in the appellate courts. But even if you are before a High Court judge, in a appellate jurisdiction, I think you got to bear that in mind. But of course, if you're before 3 judges or 5 judges, it requires a little more focusedness. Very, very basic things is that you must know your facts. You do not appear without knowing the facts. That is so essential. There may be occasions after some years at the bar, you may have benefited, you may have succeeded without knowing much of the facts, but a basic rule, you must know the facts. You must know basically, essentially what happened in the High Court, the various processes, the date when the order was given, whether there was a stay, all of those things, you must have it. And if you cannot remember little details the way that I cannot, there are some counsel who can, who will have it in their mind. You must note it down very clearly in pieces of, in nice pieces of paper, so that you are there when judges ask you. Make cross references, and if the appeal is, and if, particularly if you're the appellant, you must do, if there is more than a few bundles, please make a core bundle of your core documents. That helps. The idea is, as Mr. Naga pointed out, is for us to influence, persuade the judges in a good way. And thus all these little things helps. So when you have to look at a document, it's all one document. You don't go from one bundle to another bundle. It all just irritates the judges. And the idea is not to lose them. So that's the first position. Second is, do not go and read your written submissions from page to page. Don't waste time, because you lose the judges. You must be able to take out the very strong points and have your speaking notes. That's a 2-3 page document that you should prepare, that you will know exactly the structure of your submission. So you will make reference to your submission in your speaking notes, and the speaking notes is something for you. You go through it so that you're very familiar, you exactly know the structure of your appeal. So don't read your submissions, the written submissions that you have done, because you lose your judges, and you will then, they will be reading your submission as you are reading it, and they are not looking at you, and they're not focusing on the position that you are. So don't read your submissions. Third position, my suggestion to, and this is what I do, and this is what my pupil master, the late Datuk Peter Muni, guided me, is take your strongest point. If you're an appellant, take the strongest point, look at the judgment, go through the basic facts, because you're the appellant, you need to appraise the judges of the basic facts. And if usually High Court judges set out the facts, and maybe you could just go through it, and it is better you go through the judgment where the judge has set out the facts, especially if it is neutral, and then go to the documents if you want to refer the documents, and quickly take to the passage of the judgment of the High Court that you want to attack. And that must be where the judge has made an error in the law. It is in as much as there are a number of cases in the law reports that talks about where the court has reversed the findings of fact. It is always prudent to attack an error of law first. It may be not the central position of your appeal, because your appeal may be to reverse some of the findings, but don't go there. Go first to the error of law. make that your first starting position, and hopefully the error of law is more obvious, and then you're already getting the judge to listen, and then look at the facts, and then correct the judge, and see how you can persuade the appeal court to change their mind on the findings of fact. Because remember, Mr. Naga has already pointed out to you that the High Court judge has the advantage that the demeanor, watching, observing the witness. So appeal courts are very reluctant to change, reverse findings of fact. So you must not attack that in the first position. If you have a weak point, but you want to raise it, tell the judges. Deal with your first point, your strong point. When you go to your weak point, tell the judges so that you're not seen as exaggerating your strength of your case. Because if you do not make mention that it is your weak point, your opponent, and if you are acting for the respondent, responding to the appeal, you must quickly attack the weakest part of the appellant's case. Do not deal with the appellant's case in the same way as the appellant has done it. You will deal with it because you want to show that the submission made by the appellant solicitors counsel is not as strong as it may appear. So deal with the weakest. You as when responding, deal with the weakest point. Very important. Don't, unless you think that you can manage all the points that they have raised, yes, in an effective way, take the weakest point and then build up. The most difficult, leave it a little later. Don't start with the most difficult. Start with the easiest. I think that is, from time to time, you will have to take a position a little adverse to the view taken by the appeal court. There are times that you have to do that. As counsel, that is your responsibility, because you are representing your client, and the mere fact that a judge takes an adverse position, you shouldn't just accept and move on. You cannot, unless the point can be neutralized later. There are two ways of dealing with an adverse position taken by judge. If you have an effective answer, you can deal with it immediately. But if you don't have an effective answer, my suggestion is you deal with it after you have pointed out, if your appellant pointed out the error of the court. And the court from which you're appealing. Otherwise, you get into a distraction with the judge, and we are counsel, there are judges make decisions, and if you want to attack a position taken by judge as the first position, you must be sure that you have a very strong position. Otherwise, it is just flogging a dead horse, and you shouldn't waste time there. Yeah. And I think it will not have any advantage for your client. I think this is the most important thing in regard to your oral submission when you're dealing with the court. But when a judge asks you a question in the course of your submission, do not ignore it. They get very annoyed. You must deal with it in a smart way. Sometimes, and the best method is if you can deal with it in the course of your submission, judge asks a question, please deal with it immediately. Do not stick to the text of your submission, your note, or your speaking notes. It is not the smart idea. That's when judges ask you a question. Then you have got your written submission and your oral submission. You know, I tell my young colleagues who help me prepare my written notes, written submission, first draft, you know, at some stage, and I don't know how many of you here are my age, but when there are grammatical errors, clerical errors, all that puts off people. Judges have told me that the quality of language, grammar is so bad these days. So make sure that your grammar, clerical, your reading becomes a pleasure reading your notes, reading your submission. And as Mr. Naga pointed out, Judge Nalini has given a very clear indication of what should be in a written submission. And thus, you got to be very, very clear that your written submission, and if it is a very complex case, have an executive summary. Set out your primary position on the first 2 pages so that the judges quickly understand it before they get into the details. And then you get into the oral submission and you deal with the oral submission. I guess, you know, recently I had a case. I won in the High Court. I won in the Court of Appeal, and came the Court of Appeal, and I had Nalini and Marilyn. I cannot remember who was chairing. I think Chief Justice. This was sometimes I call my cases ugly cases, and this is one of the ugly cases. Revenue had applied to dissolve, to avoid a dissolution of a company under the Companies Act. But they applied before the expiry of the 2 years after the dissolution, but the matter had not been dealt with by the court within the 2-year period. Trial date fixed. I took objection. I filed a 14A application in the High Court, and the High Court, and my only point was, has the High Court jurisdiction to give the order under section 535? And if you read 535, it says the court may at any time within 2 years after the dissolution on the application make an order. So I took the position, Judge, 2 years is over, you have no jurisdiction, could the application stand dismissed? High Court judge accepted, went up to the appeal, accepted. But the facts against my client were so miserable. Nalini and Marilyn started off, Judge Nalini and Judge Marilyn started off by saying, Naban, we have read, we don't like questions of law taken out in vacuum and dealt with because we need the facts. And the facts are not so favorable to my client because the allegation of IRB is that my client owed about $70 million in taxes, and they had managed to dissolve the company. That was just some years ago before they came to see me. So I knew the mood of the Supreme Court, and leave had already been granted. So I had to quickly think of on my feet. Sometimes, if I had pushed the position, it was clear that they would have accepted a decision of the High Court in another case where the judge thought that the 2-year position applied to the time of application and not the time of for the court to make the order. And we had English cases supporting that position, but in the English case had various commas that, and our legislation was slightly different in regard to the commas and the emphasis given in the legislation. So the middle ground proposed by judge just was, we will have the matter back to the High Court for the High Court to deal with it together with the facts and the no order as to cause, and both parties go back to High Court. And sometimes you have to take the middle ground. It's very important to ensure you preserve your position. In this case, the appellant was not even asked to submit. The federal court came clearly taking a position that this is not what they want to do. And if I had pushed the position, they might have just allowed the appeal and taken the position of the English courts without making the fine distinction in the commas. So thus, finally, sometimes you have to find a smart way of preserving your client's position or recovering whatever you can for the client. But please remember, you must take client's instructions. In any kind of compromises, I have seen cases where clients have come complaining to me that counsel took the position without regard to client. So bear that in mind. Any compromise, any position you want to take, please have it clearly client's instructions. With that, that I guess ends my little short presentation. Thanks.
Thank you, Datuk Naban. Very insightful indeed. Key takeaways, especially in relation to moving quickly to present the passage in relation to the ground of judgment, to attack the error of law, effective answers to deal with questions which are put forth immediately, otherwise dealing with it later once the error has been highlighted. Questions by the bench not being avoided or evaded for any reason whatsoever. And the anecdote, very insightful, particularly in relation to the fact that we ought to be always mindful of clients' instructions as we move along in the cause of appeal at any point. So there we have it, dear audience, presentation from two senior members of the bar. And we now move on to open the floor to questions. We have 8 questions thus far. We have one here for both Datuk Naban and Mr. Naga from Rachel. The question goes, good evening, Datuk Naban, Mr. Naga. What would you say are the golden rules to be mindful of when drafting submissions? Thank you. I think, Rachel, much of points on this has been addressed during their presentation. So, Datuk Naban, Mr. Naga, anything particularly you'd like to add insofar as this question is concerned?
Let Datuk start first.
Rachel, thank you for the question. It's essentially, I think, because this is an appellate submission, you must, and if you are the appellant, set out the basic facts, make references to the appeal record, so that if the court wants to look at the relevant document, they don't have to plow through things, because the idea is to making life easy for the court. And if you have a core bundle, make reference to the core bundle. That's the first rule. Second, cardinal rules. You must, if you're making reference to the authorities, you must also make reference clearly with your bundle to the relevant pages and of the report, as well as your bundle of authorities. Second position. Third position is, it is, as Judge Nalini has pointed out, these are the basic things that you have to. Sometimes it is a little difficult to set out the obitas and the ratios, but always cite cases that as the ratio of the point that you are making, not unless you couldn't find it. Very difficult that if you say you cannot find it, if you do enough research, I'm sure you will be able to. That would be the better position. And if that is supported by the various ratios, obitas in other subsequent cases, that will be fine. But I think ratio is the more important position. I think these are the immediate things that come to my mind. Mr. Naga, please.
Okay, I read number of judgments of the appellate court in Singapore, and I realized that there is a practice that they have always followed. In preparing the written submissions, counsels have put forward what they believe are the issues that the appellate court should determine. And that is important, because if you set out the issues succinctly in your submission, then the structure of your submission, the rest of the structure would fit into those issues. And I think it will make the appellate judge's task easier, and it will also be easy for you to advance your argument, to persuade why your position should be accepted. I think that is very, very important. Thank you.
Thank you, Datuk Naban, Mr. Naga. Next question we have is for Mr. Naga. Good evening, Mr. Naga. Since the time limit was introduced, advocates have been constrained to key points of their case. What are your tips in identifying the key points?
The key points is what Datuk Naban has highlighted, your strong points. Start off with your strong points. If you attempt to highlight the bad points, as I said, the good points might be driven off. So emphasis should be on your strong points. And if you have to attack the strength of or the weakness of your opponent's case, then focus on that as well. That should be the way you should address it. And as you would note, by the time your matter is called up in court, this is if it is in the physical appellate court, and it might be 5th on the line or the 10th on the list. And don't forget that the judges would be tired. They would want to hear your appeal and dispose it off as quickly as possible. So that being the case, it would be important to start off with your strong points.
Thank you, Mr. Naga. That aspect insofar as the judge being worn out by the end, if your matter is at the later part of the list, that is also an important thing to be mindful of as an advocate. Okay, question number 3 and 4, I think it relates to points already addressed sufficiently. We will go for the next one, which is specifically for Datuk Naban. Good evening, Datuk Naban. What is the most drastic change you have seen throughout your journey? I suppose something very broad like this, we will relate it to in the context of appeals. Datuk Naban?
Essentially, in the beginning, I'm sure Ms. Naga will 40 years ago, we had fewer judges, much fewer lawyers than we have now. So most of our appeal court judges, high court judges, know counsels who appear before them. That is a great advantage, because the judges know that here is a lawyer who does not mislead, does not exaggerate, goes to the point, and they are comfortable in this authority you're citing. They know you would have done enough research that the authority that you are citing has not been reversed, all of those things. And these are all very essential things. But now we have so many lawyers, so many judges. So it is so essential for you to do all that. And this is what has changed. So your preparation, you cannot not think of everything, because judge may want to ask you the most simplest of question, and you must be ready to give that answer. The judge may ask you a point that refers to a notes of proceedings, because you're making a statement in a submission, you had not made reference to that statement in the notes of proceeding. Judge might ask you, where is it? You must be able to quickly do it. That has changed, because judges generally these days, I've got so many lawyers, they are stressed. It's not like the days when Mr. Naga started a year before. The bar was much, much smaller, and it was much easier. That has changed. Of course, opponent, in the old days, you will have the Datuk Sri Ram, Cyrus, K.S. Narayan, very few, Palasundra. These are the people whom you have generally have cases with. Now you have many more, and each of them have their own idiosyncrasies, so you don't take them for granted. So these are, I think, the few things that has so drastically changed, and thus it requires us to be that more prepared, that much more prepared. Yeah, that's.
Thank you, Datuk Naban.
If I may add one more point on that, it's a useful point. Because of the fact that the appellate bar has grown compared to those days, you lose the familiarity with the appellate, some of the appellate judges. And when in the course of your submission, if you were to make a proposition of the law, in those days, because of the fact that the judges know you, they would understand that you would have authority to support that particular proposition, and they would accept it on your submission. Unlike now, I think some of the propositions that you would have to make, you would have to then follow up to support it with the authority, and would have to take the appellate judges through that authority. So that only shows the growth of the appellate bar and the new appellate lawyers and judges who have grown during the time. So to further support Datuk Naban's argument.
Thank you, Mr. Naga. Indeed. Okay, I think we will just take one more question, and then we will call it a day. We will close. We have one here for both Datuk Naban and Mr. Naga. The question is, our courts are moving towards digitalizing our justice system. For example, we have e-filing system and virtual hearing. How is the current system different from before? And how did both you, Datuk Naban and Mr. Naga, who have been practicing for a very long time, get accustomed to these technological changes?
Mr. Naga, could you please?
Yeah.
Thanks.
Over the last 2 years especially, it's been difficult for most of the senior advocates. And what I believe is that most of the senior advocates who appear in appellate courts or appellate hearings generally supported by a junior counsel who would probably be assisting the senior advocate in managing the IT issues and in sharing documents, because it is very difficult for senior advocates to do a double task of trying to share documents at the same time to focus their submission. So that is how I believe most of the senior advocates practice in the appellate court nowadays. Then the other important point is this. It is equally important that you should get a particular junior who supports you, who is familiar with the appeal record. If you have somebody to assist you who is not familiar, he would be equally at loss with you in sharing documents so that the court will be able to follow your submission. So it is not any junior would be able to help. The person who has been with the senior appellate advocate who has assisted in the appeal would be the preferred choice. And that is the change that we have seen. Datuk Naban, do you have anything else?
I think you were very comprehensive, Naga. Thanks. I guess we finish. Okay, sure. Datuk Naban, I know I said last question, but there appears to be one question which has not been addressed in any aspect thus far, and I think it's quite interesting. So I propose we take it. It's from Vanessa Marimutu. It says, any advice or insights for presenting an appeal where you know it's a losing battle, but the client's instructions are to appeal anyway? Any one of you? You know, there are times that you, as practitioners, clients know that they've got a weak case, and yet they want you to present it as best as you can. These are, I think, golden opportunities for you, particularly if you are young, to quickly tell the court that this is a very difficult appeal to start off with. Show frankness, candidness, and then take your best point there. You come out as judges will remember that this person came very honest, very candid, because remember, Justice Nalini and we are all taught almost in the beginning of our law school that we are officers of the court first. We represent our client, we do the best for our client, but always bearing in mind the officers of the court. So that is all, these are little points that over the years will do you well. So when clients tell you that, you can say, do not say, I don't think that they have got a case. You know, you got to put it in a smart way. But difficult case, my strongest point is this, I will deal with it, and hopefully, and when you are very candid, very earnest, the chances of the court giving you an opportunity of presenting your case is much better than trying to pull wool over judges. That's my experience. Thanks. Thank you, Datuk Naban. Mr. Naga, anything? Otherwise,
no, I think he summarized it quite well. I think that's basically the issue. So it is important for appellate advocates to establish credibility with the appellate judges. And this is one way of doing that. Because don't forget, you would have to appear before the appellate judges on another day, and they will remember you. That's important.
Okay, I think that is all we have for today. We will attempt to answer the questions, take it separately. I see you have a question as well, and Zafira. But that is all time we have for today. Thank you everyone for indulging us. It was a very valuable, insightful session. Thank you to both speakers. We hope the listeners have gained something from today's talk, and we look forward to host you soon again with another topic. Thank you all. Have a good day.
Thank you. Bye.
Thank you.
Bye.